Good. Welcome to the May 15th meeting of the British Empire Study Group. You're in for a real treat. Thank you for adjusting your time schedules and joining us a little bit early. This is a great topic and we want our presenter to be fresh. And he's in England, as you may or may not know, so we want him to be able to stay awake. At this time, I am going to turn it over to my co-chair, Robert Lutens, to introduce tonight's speaker. Robert?
Thanks, Joan. Welcome, everyone, to the May British Empire Study Group presentation, Copyright Law in the World of Philately. The presentation this evening will cover copyright basics, the lifetime of copyright, and the impact of copyright on philatelists in two regards: how they interact with copyrights as creators of copyright works, and how they interact with copyright as users of copyright works. Professor Oppenheim will also cover the issue of orphan works. His expertise is in United Kingdom copyright law, but he'll cover other countries, such as the United States as well. Most of the broad principles of copyright law are the same in all countries, but there are differences in detail from one country to another, so this should be borne in mind. A few words about our presenter this evening. Professor Charles Oppenheim is a Fellow of the Royal Philatelic Society of London and was, until 2009, Professor of Information Science and Head of the Department of Information Science at Loughborough University in Leicestershire, England. Before taking early retirement, prior to Loughborough, he held posts in other academic institutions, and for 12 years worked as a senior manager in the scholarly electronic publishing industry. He's now an independent consultant as well as a visiting professor at two United Kingdom universities. He lives in Aberdeen, Scotland. Charles, like so many philatelists, started collecting stamps around the age of 11, but he stopped when he went to university. He resumed collecting after visiting the London 1980 International Stamp Exhibition, after being persuaded to attend by a work colleague who was a fellow of the Royal Philatelic Society of London. Charles' primary philatelic focus is thematics, specifically chess. He is membership secretary of the British Thematic Association, is active in his local Aberdeen Philatelic Society, and is a member of the Publications Committee of the Royal Philatelic Society of London. So without further ado, here is our esteemed presenter this evening, Professor Charles Oppenheim.
Hello and welcome everybody. I will go straight into my talk. So if I could have my first slide, please. Okay, so this broadly is the title of my talk. Next slide. So my presentation is under a Creative Commons license. That is to say, this presentation, this PowerPoint presentation. This means that anyone can download, copy, and share this presentation with anyone else, no charge, as long as you credit me, Charles Oppenheim, and as long as you don't make any changes, however minor, to the presentation, and as long as you don't make any money from using my presentation. My contact details you'll see later on during my talk. Next slide. So, as it has already been indicated, I will be covering basics of copyright, ownership, also assignments and licenses, advice for philatelists as both users of copyright material and as creators, infringement and exceptions to copyright. I'll explain all this, or what these terms mean. Problem of orphan works. Again, I will explain what I mean by orphan works. My risk equation, which is designed for people who really are unsure whether they can or cannot do something which is potentially infringement. I do stress I'm not a lawyer, so I can't take responsibility for any actions you might take or not take as a result of this talk, but I'm always happy to informally advise. This is my email address, and feel free to make a note of that email address, and I will, and later on, you can contact me by email and ask me any follow-up questions as necessary. Okay, so copyright will protect you from pirates and make you a fortune. Well, that's not really true, but it is certainly worth saying that potentially copyright can be very helpful for people, particularly if they're publishing a book on a topic and it sells well. Okay, next slide. So, question I will answer is it okay to reproduce the images in the next two slides? So, can I see the next slide? There you see some typical stamps and a postmark, a bishop mark, I think, or some sort of postmark, and the next slide again. Is it okay to reproduce these things? Next slide. Let's talk you through the copyright basics. It is automatic. There's no need to register or requirement for a C and a circle symbol in most countries. USA is different, and I'll talk about that in a minute or two. It comes into existence as soon as somebody creates something new. In other words, not copied, and is in a fixed format. In other words, it doesn't vanish instantly. It applies to text, images, moving images, sound recordings, dramatic works, broadcasts, and this presentation. There's also something called moral rights, which is the right to be identified as the creator of something and the right to object to derogatory treatment of the work. These rights apply in the European Union, in the United Kingdom, British Commonwealth, and some other countries, but by no means all other countries. The lifetime of copyright is normally 70 years after the end of the year that the creator died, but some countries have different rules. When the creator dies, copyright continues because it goes on for 70 years longer, and typically their copyright will often pass to their heirs and successors. Anything published that is really old, and I'll define publishing in a second, in other words, before 1900, is probably out of copyright, so you can do what you like with it. Publishing does not just relate to formal publishing, but is anything which has been made available to the public, whether for a fee or not, is likely to be considered to be published. This includes things like stamps, printed ephemera, catalogues, postmarks, meter marks, as well as things you would normally consider to be published, like books, reports, magazine articles, and stuff on the internet. The lifetime for unpublished manuscript can, however, be much longer in some countries, so care is needed when dealing with them. I'll say a bit more about them later on. If you take a photograph of an unpublished copyright work, say of a penny blank stamp, 1840 first ever British stamp. Do you get copyright in that photo? No, unless you use significant skill and effort in taking the photo. For example, use of careful lighting to highlight a particular aspect. Next slide. In the USA, registration and a C in a circle symbol is required before a lawsuit can be filed, and this creates the possibility of enhanced damages in the case of infringement. You need to register online at the US Copyright Office's website. It reviews applications for obvious errors or lack of copyrightable material, and then issues a certificate of registration. The Copyright Office does not compare the work against existing works. So registration makes it possible to sue for infringement, and I'll talk about that a bit more, and get significant damages if it's proven in the USA. Now, the USA is out of line with most countries where no registration or use of a C in a circle symbol is necessary to gain or exercise legal rights. The US Postal Service uses C in a circle symbol on its stamps, and there is a market for its stamps with the C in a circle symbol in the salvage. Albums for such collectors also exist. Next slide. And here's an example of a copyright notice on a stamp salvage. Next slide. The Smithsonian National Postal Museum concluded that covers, that is to say envelopes with particular stamps and postmarks on them, are not copyrightable. I agree, so as long as there's nothing special about a cover, it has no copyright. If the cover includes a stamp or postmark that may be copyright, then care may be needed when reproducing it. Next slide. Okay. So what copyright gives the owner is the right to prevent third parties from reproducing, distributing, renting out for a fee, lending out for nothing, performing, communicating by electronic means, amending or translating the work without permission. If someone does it with any of these things without permission, they have infringed the copyright and can be sued by the owner of the copyright, or in some circumstances can be prosecuted by the state. So just because you own a particular stamp or cover or artist proof, fancy postmark, book, magazine article, and so on, etc., does not necessarily mean you own the copyright in it. So you may not be able to do what you like with it. In many, but not all countries, the creator, not always the same as the owner, can also sue for infringement of moral rights. As I indicated, moral rights are confined to only a small number of countries. For example, infringement of moral rights might be failing to credit who created the item, or amending the item in such a way to diminish the reputation of the creator. Next slide. There are other rights of relevance which apply in philately. Registered trademarks can be very important to catalogue publishers, to stamp issuing authorities, to auction houses, to stamp dealers. Database rights in those countries that offer them, which are mainly European Union member states and the United Kingdom, can be important to catalogue publishers. Next slide, please. So let's have a look at stamp catalogues. Simple facts like the Stanley Gibbons catalogue number for the penny black is 1 and its price used is £525 have no protection. A collection of facts, however, might have copyright protection, but only if they are original by means of novel selection or arrangement. So arranging a list of stamps in date order and then face value order for each issue with catalogue numbers in simple numeric sequence is obvious and therefore has no copyright protection. But say a thematic or topical catalogue or a specialist catalogue with commentary would be protected. There may be database rights in those countries which allow this if the catalogue publisher has made a substantial investment in obtaining, verifying, and presenting the contents of the catalogue. So the next slide, please. You get various catalogue publisher statements. The one below here is my own translating from French of Yves a Teller catalogue. Catalogue is owned by the Société des Éditions Yves a Teller. Reproduction is not permitted in all or in part. This applies to text, images, tables, and catalogue number. Oh, and Michel catalogue. No reproduction of text, images, unless owned by a third party, numbering, or prices. Next slide. Scott catalogue. Permission is hereby given for the use of material in this book and covered by copyright if A, the material is used in advertising matter, circulars, or price lists for offering stamps for sale, and the price is listed there. B, incidental use limited in scope and length, and C, is not used as part of any catalogue, stamp album, or computerized system based on our catalogue system or in an evaluations of stamps not offered for sale. And such use is not competitive with the business of this publisher. Any use of the material which does not satisfy all of these conditions is forbidden unless permission in each instant is given in writing by the publisher. So you have to ask Scott for permission. Next slide. Stanley Gibbons statement. The contents of this catalogue, including the numbering system and illustrations, are fully protected by copyright. No part of this publication may be reproduced, stored in a retrieval system, or transmitted in any form or by any means without the prior permission of Stanley Gibbons Limited. Okay, next slide. Now, there was a German court case. I've given the details there, between the German catalogue publisher Michel and Philotax, I don't know how you pronounce it, Philotax, a German CD-ROM publisher of stamp catalogues. The case was about whether Philotax could use Michel numbers in its CD-ROM catalogue without a license from Michel. Michel claimed that its numbering system was protected by copyright and/or database right. Importantly, Michel lost the case on appeal. Key factor was that the court decided that Michel catalog numbers were just an incremental sequence without any inherent value added. There were other factors involved as well. This case didn't get much publicity, but in my view is very significant. Michel are knowingly setting out misleading statements in their catalogues. You remember they had a very hard approach. So, summing up on catalogues, the Stanley Gibbons, Michel, and Evert statements are misleading. They take no account of exceptions to copyright, which I'm going to explain in a minute. And in any case, I believe the claim that they own the copyright is incorrect in view of the Michel court decision. However, and this is a curious thing, there is nothing illegal about claiming something is covered by your copyright when it is not, or failing to draw attention to the exceptions to copyright, which will be discussed by me later. This is the quirk of copyright law, very unfortunate in my view. In my opinion, publishers should always insert the words, except as otherwise permitted by law, no part may be reproduced, something similar, but they are not obliged to. The Scott statement is by far the best at the moment, and I really wish other catalogue publishers would accept that they have to put in this sort of wording, except as permitted by law. Next slide. Okay, so who owns the copyright in something? To begin with, it's normally the creator, whoever first created the creation in the course of their employee duties. If in the course of their employee duties they created this item, then the employer owns the copyright. It's work for hire in US parlance. If they created it as a freelancer or as part of the commissioned piece of work, then it depends on whatever commissioning contract they have entered into. This is relevant to artists, designers of stamps and postmarks and illustrated covers, and to stamp issuing authorities. If a philatelist create their own images for an article or display, as long as they did not copy it from somewhere else, they would normally own the copyright in what they created, but not if it's just very simple facts. The owner, if they wish, can choose to assign, in other words, transfer the copyright to a third party, or to license, give permission to copy whilst retaining copyright for themselves to a third party to do things with their creation. They may charge for such things, but not obliged to. I presume catalogue publishers have obtained licenses from stamp issuing authority to reproduce the images of in-copyright stamps that they reproduce. Joint ownership is always possible if more than one person was involved in the creation of an item. If you take a stamp, postmark, etc., and blow it up to show a particular feature, and you use skill and effort to do that, you may well own copyright in this new image, and at the same time infringe copyright in the original. And that might sound crazy, but these sorts of situations are not unknown. Expertizing services often create images of items submitted to them. Because of the skill and effort involved, such images are probably copyright of the expertizing service. But again, they might be infringing somebody else's copyright at the same time. Next slide. So, items where copyright is owned by third parties will include things like pre-printed stamp albums, postage stamps, postmarks, meter marks, first day covers, letters, the content of letters and other types of correspondence, stamp catalogues, big and small, likely to be copyright overall, auction house publications, books and articles on philatelic or other interests, philatelic websites, relevant images of all kinds, postcards. These are all things where copyright is likely to be owned by some third party. Next slide. Items where copyright is initially owned by a collector will be pages from a collector's collection, including commentary on their collection on those pages, perhaps for a club display or competitive display, magazine articles, book chapters, entire books written by the collector, letters sent to the editor of magazines. In many cases, they may choose to or have to assign their copyright to a publisher in order to get their book chapter, book, or magazine article published. That's a different matter. The opinions offered to expertizing services almost certainly will be copyright of the person giving that written opinion. Text and audio recordings of talks that a collector may give, websites you create or help in creating, and images of relevance you create for publications, whether print or online. Next slide. So, copyright infringement, this occurs when a copyright work is used without the permission of the copyright owner and falls under one of the so-called exclusive acts, where only the copyright owner or someone authorized by the owner does it. And it does not fall under the list of exceptions which I'm about to cover. Now, let's have a look at Tonya Gillings. She uses postage stamps to create paintings. She owns the copyright in her paintings. However, she may be infringing a stamp issuing authority's copyright by the incorporation of the stamps, especially as her creations are for commercial purposes. Next slide will show you an example of the sorts of things that she creates. So that there you see a postage stamp, but it's got a whole lot of artistic stuff around it. Next slide. So, making a copy of a stamp or postmark, etc., without any particular skill or judgment will not give you copyright in the image you created, and you may well infringe the copyright of the original. In practice, though, stamp issuing authorities are very relaxed about the use of their images of their stamps and their postmarks by philatelists and philatelic organizations because it helps improve the sales of their stamps and postmarks. Next slide. Now, I mentioned exceptions to copyright. The law allows activities which would otherwise be infringement to be done without having to ask permission or having to pay any fees. It's often called fair use or fair dealing. Fair use is a US term. The most important ones relating to philately is copying an item for non-commercial research or private study. If the purpose is for research for a book or a report which will be sold commercially, then this exception does not apply, so you may well be infringing. Copying an item for criticism or review. Criticism doesn't necessarily mean you have to criticize. It may well be you're just analyzing and commentating, making comments about the item. So criticism or review is interpreted generously. Copying for non-commercial educational purposes. This is the basis on which I have reproduced the images for this talk, because it's for educational purposes, it's for a webinar, and I'm not making any money out of this webinar. Copying for quotation purposes is allowed, whether for commercial purposes or not. Reproduction of stamps and covers in auction catalogues are allowed, and I would argue this also applies to online services such as Delcamp and eBay. Philatelic libraries can make copies of items held by the library for their patrons, or can allow patrons to do self-service copying. In most countries, there are exceptions allowing the scanning or other copying of material for preservation and archiving purposes. There is standard wording on copying request forms that patrons must sign. Libraries work together to share digitizing workloads or digitizing materials, belong to specialist material societies on an exchange basis. That almost certainly is okay under an exception to copyright for the libraries. Next slide. Orphan works. This is an important subject area. An orphan work is something that is still protected by copyright, but the creator or subsequent owner, if it was assigned, is unknown or untraceable. There are an awful lot of them in the philately. Examples include unpublished reports, letters, the contents of letters, publications of unknown authorship or provenance. If the original was unpublished, for example, letters, their copyright lifetime can be very long. Rules vary from country to country, but can be literally hundreds of years long. Some countries have laws that permit use of such works by means of paying a license fee to a centralized service, which will then pay to anybody who comes out of the woodwork, proving they are in fact the copyright owner of the particular item. And some countries provide for an exception to copyright works, for orphan works, under restricted circumstances. But unfortunately, in a lot, probably the majority of cases of orphan works, you will not be able to take advantage of such schemes or exceptions. So they're still in copyright. Okay, next slide. So, typical orphan works problem: a specialist philatelic society closes. Someone would like to reproduce articles from its now defunct magazine. It's not clear if those articles' copyright were owned by the authors or the philatelic society in question. There's no one to approach for permission to reproduce. You need to make a risk assessment, and I'll talk about my risk formula in a later slide. Next slide. So, impact of copyright on some publishers. As noted earlier, in the case of catalogue publishers, they actually have little protection for their country-based catalogues, and their statements about it are misleading, but they may well have trademark protection, and I suspect they probably all do. Those of you who give philatelic displays will normally have nothing to worry about. Be careful when reproducing maps, photographs, and the like, because you will own copyright in the original text and images you've added, and quite possibly selection of and arrangement on sheets. And you may argue that any copying, displaying is for educational purposes. Authors of philatelic books and articles must ensure any third-party material they reproduce, including text and images, are either so old to be out of copyright, but remember that unpublished copyright works can go on, unpublished works, their copyright can go on for a surprisingly long time. Or you have explicit permission from the copyright owner, and or the use falls under an exception to copyright. Don't just assume it's okay. Authors will normally own the copyright in their writings. Philatelic monograph and magazine publishers must ensure anything they reproduce is clear of copyright. So usually require anyone submitting something to be published by them to confirm that nothing the author has supplied will infringe copyright or indeed any other right, such as registered trademarks. The publisher may or may not require the author to assign copyright in the text submitted to them, a quite separate matter. Publishers must be aware of not infringing the author's moral rights where the author is based in a country which has moral rights. Any not-for-profit philatelic organization that scans materials for preservation purposes should be okay. But putting the scans on a website is potentially problematic. Pre-printed album pages will often be copyright. Digitizing your personal collection of articles, philatelic journals, etc., for your own records, say for example, for insurance purposes, may be infringement, but as long as the digitized records are not disseminated further, you should be safe. And philatelic organizations doing outreach with games, puzzles, and so on to get people interested in philately are probably okay if they reproduce stamps and postmarks for these educational purposes. It would be a very odd stamp issuing authority that objected to this popularization of philately. Next slide. So let's have a look at the impact on you as a creator and as a user. As a creator, you create many items that are initially your copyright. Things like display sheets, articles, letters to the editor for philatelic magazines, text and images for philatelic books and book chapters in your name, photographs of relevance to your collections. You may well be asked to assign your copyright to, for example, a publisher as a condition for the publisher reproducing your work. Next slide. Impact on you as a user. You will be accessing material whose copyright is owned by somebody else. Previous research about your chosen subject, other catalogs, reports, letters, magazine articles you've come across, and of course stamps and postmarks, meter marks of relevance to your collecting interest. You may well have to ask for permission to reproduce such works in your own outputs. Next slide. Digital issues. If something is posted on the web, then it can get widely disseminated at little or no cost by third party. So you've got to be cautious when reproducing materials found on the web. Copying and then archiving websites and electronic materials is normally only allowed for certain types of libraries and archives, including not-for-profit libraries and archives and national libraries and archives. If someone is not concerned about others reproducing their copyright materials, which they put on the web, they typically apply a so-called Creative Commons license to them. It says, in effect, I retain copyright, but feel free to reproduce this, and I won't charge you, as I have done with this presentation. And there is a URL there for the various types of Creative Commons licenses that are available for more details on this. Next slide. Now, this is my risk calculator, and it is important because copyright is much more to do with the management of risk than the actual law. So let A be the chances, with 0 being no chance and 1 being certain, that what you do is infringement. Let B be the chances, again, between 0 and 1, that the copyright owner will find out that your infringement has occurred, assuming that it is infringement. Let C be the chances that the owner will sue for infringement, again, between 0 and 1, where 1 is absolutely definitely. It may well not bother if the infringement is a minor thing. Let D be the likely maximum penalty involved. You can work it out in euros, pounds sterling, dollars, choose your currency as you wish. Then R, the risk, is A times B times C times D. So consider how risk you or your employing organization is. If it is likely to be very risk averse, if it is, say, a high profile organization with a reputation to protect, then it will be extremely risk averse. So decide whether to take the risk based on all this. So I'm afraid this isn't terribly helpful in most cases when you're trying to work out, do I copy this or do I not copy this? But this is the best I can offer you. Okay, next slide. This might amuse you. The US Postal Service was successfully sued for copyright infringement when it reproduced an image of the Statue of Liberty that was in a mall, a shopping mall, rather than using an image of the real Statue of Liberty. In UK law, that wouldn't have been infringement, as a statue in a privately owned mall has no copyright if anyone has the right to enter the mall. But US law is different. So that's quite an amusing little case. Next slide. Remember, children, copyright applies to you. Next slide. If someone underage is planning to give a philatelic display of some sort, they should be made aware of what they need to do to ensure they keep on the right side of copyright owner, just as you, as an adult collector, have to. Next slide. So this I've reproduced under the UK exception to copyright for non-commercial educational use. And it's a cartoon which says it's not a multiverse, it's a copyright violation. It's in fact not that funny, but it clearly was created by somebody who thought it was. So my thanks go to two people, to Joan Harmer for inviting me to give this talk in the first place and for organizing this meeting, and to Rob Luton for introducing me and for managing my slides. So thanks to both of you. Any questions? Once again, there's my email address. Okay, that's it. Thank you very much.
Well, thank you, Charles. That was extremely interesting. That's some vital information there. We've got a handful of questions here to start off with. Kendall Sanford asks, if you have an image of someone's cover, can you use it in an article without getting that owner's permission?
You should really get the owner's permission, ideally. But there may be circumstances where it's difficult to track the owner down, and then you really have to use my risk equation to decide whether to take that risk. But I would recommend you attempt to contact the owner. Yeah.
Okay, good. From Peter Moore, if you ask for permission from a publisher like Michelle or Stanley Gibbons, but the publisher does not give you an answer, what is the status of that permission request?
Yes. I'm not sure how common that problem is, but it is a problem. It kind of makes it an orphan work. So you have to use my risk equation as well, again. So basically decide whether it is worth the risk to simply go ahead.
All right. All right, Don Heller asks, is it legal to photocopy a catalog page for my own use? And secondly, can I give that photocopy to someone else? Not sell it, but give it.
I would say the answer is yes to both. Photocopying a single page for your own use is definitely okay. And to pass that single page photocopy to someone else, I'm assuming at no charge, you're not going to make any money out of handing that page over. Should be safe.
Okay. Question from an anonymous attendee. Other than giving recognition to the originator, isn't the only reason we are dealing with copyrights is to give someone the legal ability to sue someone else?
Yes, I would agree.
Affirmative.
Yes.
Okay. And finally here we have, oh no, there's some more. Manda Kowalczyk, and she says, hello, my name is Manda and I work for the National Postal Museum. This is so interesting. Could you please clarify your earlier slide stating the National Postal Museum says covers are not copywritten unless the stamp holds a copyright. Could you clarify that, Charles?
Now, what I would like is perhaps you could send that question to me by email,
Okay.
and I will think about it and give you a response.
Okay. Again, from Peter Moorer. Is bibliographic information copyrighted? Title, international SSN, ISBN, volume, pages, etc. For instance, as gathered by scientific institutions like Clavioret or Web of Science.
Yes, yeah, I would say those aren't copyrighted. Uh, they're simple facts, and you can do what you like and reproduce them, certainly.
Okay. All right, here, a question from Canada from Charles Livermore. Would exhibits be considered as educational and covered by fair use if limited copyrighted material is included?
Yes, that should be okay.
Okay. Peter Thigh, if I own an item and I scan it and then I sell it, do I still own my old image?
Yes, you can. You made the image for your own private use, and there's no reason why you can, even if you've sold the item, you still own the copyright in that item, the image. But I would recommend you do not redisseminate it or try to sell that image.
Mm-hmm.
So it's your private use.
All right. Let's see. We have Tony Plum. He wants you to elaborate on the copyright surrounding Zoom displays using covers and stamps that the displayer owns and have arranged using their own PowerPoint creation.
Well, that's in effect what I've done today.
Mhm.
And I would argue that will be for educational use, assuming wherever you're based has an exception to copyright for educational purposes.
Okay. Ian Bridle asks us, substantially copying with some text and picture changes, philatelic articles for a local stamp club newsletter to educate members on something that is of interest to the local club members. Is this copyright infringement, or could it be claimed as being used for educational purposes?
Yeah, I would argue that's used for educational purposes. Yeah.
Yeah, I would agree with that. Ian Bridle again says, at philatelic exhibitions, the organizers do not allow photographs to be taken of exhibits. Is this due to copyright law?
Oh, that's interesting. I wasn't aware of that. At
I wasn't
exhibitions
either.
I have been to, I've seen people busy taking photographs of exhibits. Uh, but if it's a condition of entry into the exhibition, that that the people who are walking in are told you may not make photographs, you may not take photographs of the exhibit. I suspect they're being overcautious, but you should respect it because it's a condition of you being allowed in. So it's very frustrating.
That's that's an issue to do with the contract between you and the people running the show, not between you and the person whose material you're photographing. You may be infringing their copyright, but the contract between you and the exhibit, the people running the exhibit, is what can they do to you? Nothing. They could kick you out, but they can't sue you.
No, they can't sue you, but they could say, yes, you've broken the contract by doing things which we don't permit. Yes.
This is a thing that comes up when people go to museums and the museums claim copyright on things that are so old they're out of copyright, and they say it's our copyright. It's not. You can't copyright something that's fallen into the public domain. It's called
Absolutely.
copy fraud.
Yes,
It goes on
absolutely.
all the time,
Yes,
unfortunately.
yes. I understand, and it's an attitude which I really do not like, because
I
they're
agree.
basically being deliberately misleading about copyright.
There's a big case that took place between Wikipedia and the National Portrait, I believe it was the National Portrait Gallery in the UK, where
Yeah,
somebody downloaded the digital files of photographs of people. It was a big case. They tried to sue on it. It went nowhere. The question from the NPR affects that. If the item on the cover is old enough to be out of copyright, you definitely have no problem with photographing the cover. Some
absolutely.
newer material, that's different.
Maybe, yeah, maybe. Yes, I agree with everything you say.
Well, thanks for that, Carl.
I've got more things to say, but
okay, go
I
ahead.
don't want to take over the show.
Why don't we let Raphael go? He's been very
Yeah.
patient.
Yes, he has.
Hi, thank you for the talk. Very interesting the topics. The question I have is regarding like covers. Let's say that I buy a cover or someone else buys it from eBay,
Yeah.
and then I use the pictures for an article, but now someone else owns it, and someone else before that person also owned it. So I'm breaking the law or not?
Hang on. You are selling the item. Have I got that right?
No, let's say that I just someone else is selling it, and I
Oh,
just took a
someone else
picture.
is selling.
Yeah.
Yeah. But you make a copy of the item.
Yeah, I downloaded a picture. I took a snapshot and maybe put it in an article, and
Ah, interesting. Yes, you might be infringing
because I've
copyright.
seen people doing that a lot, and then they say, "Oh, from eBay." They just only say from eBay, and I've seen also quoting action catalogs as well.
Yes, yeah, that is quite dodgy, I would argue. So my advice would be not to do it unless you've got a very good reason for doing it and you're willing to take the risk.
And let's say that if I own it at one time and now I sold it, like I think you answered that before. I just
Yes.
can keep it for myself, but not
You
disseminate.
keep it for yourself. Absolutely. Yeah. Yeah.
Thank you
I've
so much.
seen-
Really interesting.
I've seen illustrations made of stamps from eBay that have been highlighted as forgeries. So
Yes.
it's educating people that beware that these forgeries are out there. I'm assuming that's okay to
That's
take a
okay.
snapshot and
Yes, I would regard that as educational and indeed important.
All right. John Copeland.
Yeah, a couple of comments. First of all, think about leaving copyright in your will if you've written articles or books. You might want to leave it, say, to a philatelic society rather than leave it for your executors to sort out. Secondly, some governments have shorter copyright periods than individuals. So if UK government publishes items, normally it's a 50-year period.
Yeah.
And I believe the United States, in some cases, there is no copyright.
Yeah.
And of course, this may well apply to stamps, unless, of course, the post office has been privatized. I think, yeah. And the other thing, thought, Charles, PDFs on the internet, I think there will be an implied license to download and store,
Yeah,
as opposed to republish.
yeah,
I don't know.
yes.
Right.
And certainly, as far as wills are concerned, there is no problem at all about you having in your will a statement or getting your heirs and successors to pass copyright on to, say, a philatelic society, a worthy cause, or whatever that you have chosen to be the recipient. And indeed, I have done exactly that myself.
Thank you.
All right, Tom Droge.
Okay, and for those of you who don't know about people who get copyrights, materials stolen from them, that's Tom with his Stamp Auction Network. So how many people have downloaded an image from Stamp Auction Network?
Well, yeah. I'd be
That's a
glad to.
confession.
Okay, so Tom Droge, I'm with Stamp Auction Network. And by the way, we have probably 2.5 million images at Stamp Auction Network, all contributed by auction companies, posted at Stamp Auction Network. Now, I have spent a good amount of money with lawyers, very expensive lawyers, to address this topic with regard to U.S. stamps, and I can speak to the point. However, what may be true is has not been determined by the courts. But let me say this, that as a fundamental basis, any stamp produced before the USPS started to copyright stamps, which was in the late, I don't know, it's 2000 time, 1990s or something like that. The USPS started to copyright stamps. Any stamps produced by the Postal Service before that time are inherently in the public domain. They were produced by the U.S. government. Everything that the U.S. government produces is owned by us, the citizens.
Yeah.
1978, the Department of Post.
So all those classic U.S. stamps, all of them, you cannot copyright them. And now to the question of, can you enhance or do an exceptional amount of work to make them copyrightable? And the answer to that is also no. You cannot, scanning them at high resolution, color correcting them, doing anything else to, spending an hour to align the stamp so that it's perfectly square and you can see all the perforations. None of that work, no matter how much time you spend doing to that, will make something that's in the public domain a copyrightable work. Now,
that's very interesting. Could you actually make a request to you? Can you send me an email summarizing what you just said?
Well, it's all a mute point, because the thing about this is no one actually wants to have the court case that will determine it. And it's not really, it's not stamp collectors that care, but it's the museums. And, the big court case was a court case about museums that publish books of pictures of Michelangelo, and have books, and every single picture in there is out of copyright. And the museum publish that book and copyright it. And so nobody really wants to take this issue. That's the problem. So, yeah, so that's where it lies. At a basic understanding, Stamps can't be copyrighted. Now, some organizations will try to copyright them or say that they're copyrighted. Again, kind of like what you said, Charles, the publishing, the catalog publishing companies will make claims as to
Yes.
copyright nature. But that's all I can offer on the conversation. And believe me, it's been something I've been
Fascinating.
knowledgeable about for 30 years now.
Fascinating.
Yeah.
Well, thank you for that. That's very interesting.
Thank you, Tom. That was great. Clive Levinson.
Hi. I thought you might be interested in a real world case of your formula being used.
Oh, yes.
I have a website where I distribute a few hundred PDF stamp albums created by various people. They've all given me permission to host them and distribute them. In the early days, many of the creators included Scott numbers in the albums. Eventually, I got a nasty letter from Amos Publishing, the copyright holders of Scott, saying remove or court. Needless to say, I removed the albums. I, like you, felt that there's no way you can copyright a sequence of numbers that are purely in publishing order, when the stamps are actually published, distributed. But not having deep pockets, I assessed the risk. I have no interest in going to court.
Yes.
I complied.
Yes. Oh, very interesting. And I don't blame you for your decision. Yeah, I think that was a wise decision.
I still do.
Thanks for that, Clive. Paul Davey.
Interesting as usual, Charles. Thank you very much.
My pleasure.
It occurs to me that a stamp forger is creating something. He's the creator of that image.
Yes, indeed.
Could claim to own the copyright. If he's a very good forger and there's no difference, then he's obviously infringing somebody else's.
Right. Yes, I agree.
Would that be the case?
Yes, I agree with your assessment. A bad forger who produces something which is very obviously a forgery is safer in a way than a really good forger who is convincingly the same as the original. Yeah.
I'd like to see that go to court.
Joseph Giacalone, you've got a question.
Well, it's really a comment. I was in the process of writing a philatelic book. So then I was going to use Scott numbers and postage stamp images from beyond the point when they became copyrighted.
Right.
I sent a request to Scott and I got no response. I sent the check to the United States Postal Service. They cashed the check, but I got no response. So I just went forward. And I did it. I mean, I ultimately did.
And you didn't get into any trouble at all.
I was just assuming that they, didn't think it was a big deal.
Yep. Yep. This was a philatelic book, presumably.
Yeah.
Yeah. Well, yes, it would be a very strange stamp issuing authority who basically tried to squash the creation of philatelic books.
Yeah.
So you did the right thing, in fact.
I guess.
Yes. Okay, I'm happy to pack it in now, if that's okay with all of you.
We have two more questions, if you could hold
Oh,
out.
okay. It was just two.
Because there's only two, so we're going to cut it off at the last two.
Right.
Okay, I'll go ahead. I have a few comments that some people may or may not realize. You had mentioned work for hire. Work for hire in the United States requires an actual written contract stating that it's a work for hire. In other countries, that's not the case. This is a thing that you've really got to watch out for. Different countries have significantly different rules. For instance, all Russian stamps are in the public domain, but many other countries are not. US are in the public domain, those that were issued, as I mentioned, by the Department of Posts, and USPS is not until they become 70 years after the death of the author. That's the usual time. Unpublished works tend to be copyright for 120 years.
Right. Yes.
From the date that's first published. So if I publish today,
Yes.
in 2145, it'll be out of copyright.
Yeah.
Which is crazy, but that's the way it is. Basically, copying is making a derivative work. And in many cases, and even the forgers are making a derivative work. They need to attribute the original author, even though they may have created this drawing. This happens with photographs.
Sure.
I am a volunteer in copyright with Wikimedia Foundation. And one of the issues we find is people say, oh, well, it's my photograph. I took a photograph of this painting by an artist from 20 years ago.
Right.
No.
So.
You need two permissions. You need a permission from the artist, and you need the permission as a photographer.
Yes.
The other thing, so age is so important, as you've indicated. Sometimes, however, things are so simple that they really don't obtain copyright, particularly in the US. UK copyright is very strict. And there again, you've got to look at the countries. It makes a big difference where you are or where the material comes from. And that's probably one of the most important things. I had mentioned previously copy fraud, which museums do a lot. I don't understand it because if you open up the digital images of old photographs, what are you doing? You're promoting the museum, and that you would think would be a good thing. But no, apparently some museums, and there are museums and galleries who work with what's the website that has all the photographs that a lot of people put their photographs on?
Getty.
Sorry?
Getty?
No, I forgot. Anyway, I'll remember. That's the problem with as the numbers get higher, and the hair gets. Orphan works, I remember that. A thing to remember, and you probably maybe you didn't make this strong enough. Generally, the images you find on the internet are copyright to somebody.
Sure.
Unless by age. So you need to investigate a little bit. And that's very important.
Yes.
And the Creative Commons licenses you mentioned, be careful because there are different licenses. Some are very restrictive and some are not.
Absolutely.
If I release something under an NC ND license, that means you cannot really do much with it.
Sure.
You can't use it creatively, commercially. You can't make a new version of it. So be very careful. Have a read of all those Creative Commons licenses.
Absolutely.
This is not for you, Charles. You know most of this stuff, And suing, I know that in the States, there's really no point in suing because you probably haven't registered your images that you put online. So that's an issue. What we are finding nowadays, however, is that there are some people who, when you put an image on your web page, there are people who will claim very high fees if you don't attribute them properly. So if somebody has given a Creative license, Commons license for a particular usage, and you don't give the correct attribution,
Sure.
they can sue you for that, for not giving you the proper license. Those are basically the things that I see. The catalog numbers, by the way, we had a conversation a few years ago in Wikipedia about the catalog licenses, and Clive Levinson mentioned it. Somebody was using a load of Scott numbers in a big listing of stamps. And we decided that using extensive use of catalog numbers was not free enough copy. It was still copyright. Using an occasional one seemed to be okay.
Yeah.
Sorry to take up so much, but I think, there's so much. It's a terrible topic, to be honest with you. I've been dealing with it as a photographer. I would be dealing with it for about 40 years. So I've got a decent knowledge of it. Thank you so much, Charles, for your information.
Well,
My pleasure.
Thanks for sharing that, Carl.
Okay, well, Charles, thank you very much. It was very, very interesting. I know I sort of kept you here a little bit longer.
Thank you for the invitation.
Well, this is very informative. I think really well needed guidance needed in the hobby, and I think that's great. Thank everybody for being here and contributing. Carl and Tom and Peter, and it's
well,
great.
thank you again for the invitation.
Okay.
Thank you, Charles.
Thank you, Charles.
My pleasure.